Hi, everyone, and welcome to the Veterans Legal Lowdown. I'm Amy Odom. I am an attorney with CCK, and today I'm breaking down a recent decision from the Federal Circuit. The background of this case, Score versus McDonough, is that an Air Force veteran, Victor Score, was seeking to file a class action in the Veterans Court to seek relief for himself and other veterans who, like him, had been involved in the nuclear accident in Palomora, Spain. After many, many years of litigation, ultimately the Federal Circuit Court of Appeals, which is the superior court to the U.S. Court of Appeals for Veterans Claims, determined that veterans who are seeking review of a final board decision, like Mr. Score was, cannot seek class action review to include other veterans who have not also received a final decision from the Board of Veterans Appeals. So what it essentially means is that after the decision, the panel decision in Score, you can only get a class of veterans together for purposes of an appeal to the Veterans Court if the other members of the class, if the other veterans also have final board decisions that are still within the 120-day period to appeal to the Veterans Court. So this very, very, very strictly narrowed the kinds of cases where veterans can seek class action review of a board decision at the Veterans Court. Mr. Score, after receiving the panel decision, filed a motion or a petition for the panel to reconsider its decision or for a rehearing before an en banc panel of the court. And what en banc means is before all of the judges in the court. The panel was just 3 judges who made this decision, and now Mr. Score was asking either for those 3 judges to reconsider its decision or for all 9 judges to take a look at it and make a decision. Unfortunately, both requests were denied, but not without a dissent from 5 of the judges sitting on the Federal Circuit. And the dissent was very strong and has a lot of very interesting tidbits. For example, the 5 dissenting judges agreed that this panel decision really strictly narrowed the types of cases where veterans can seek class action relief. And that this was really a bad thing in a system like the VA claims adjudication system that is riddled with backlogs and errors. And the 5 judges agreed that a panel decision or a precedential decision from the Veterans Court on a single veterans decision is not a good substitute for class actions. So this is a really interesting case, something to keep an eye on, because 5 of the Federal Circuit judges dissented. This could be the next case that we may see at the United States Supreme Court. Usually when you see a split in an en banc panel like this, it's a good indication that it's a very difficult question that needs an answer from the Supreme Court. The other interesting thing about this decision is that, as it points out, other federal courts do have class action authority. And why is it that the Veterans Court is singled out for not having this authority? So keep an eye on this case. I suspect that a petition for certiorari will be filed at the Supreme Court, and then the question will be whether the Supreme Court will accept it. How could this decision impact veterans today? Not by much, because the law, as we know it from the panel decision, is that you can only have a class action in a case involving direct review of a board's decision if you have veterans who are members of the class who also have final board decisions that are appealable. Since that is the state of the law, this denial of the rehearing en banc didn't change much. Also, it doesn't change that the availability of class action relief in a case where you're seeking a writ of mandamus as opposed to review of an actual board decision is not narrowed by this case. Those rules, those are two separate kinds of cases. One is about trying to force VA to do something when you don't have a board decision yet, and one's about trying to force VA to do something when you do have a board decision. This case does not affect the rules that govern cases when you don't have a board decision. Like I said, keep an eye out on the next steps and what happens at the U.S. Supreme Court. We will, of course, provide updates as the situation progresses, so stay tuned and thanks for watching.